So with that, I'm going to introduce our speaker today, Diana Silva. She's a partner with Manko Gold, Katcher Fox out of Philadelphia, where she concentrates her practice in environmental litigation, including statutory contribution and cost recovery actions, toxic tort claims, contractual disputes, and administrative enforcement actions. She also counsels clients in environmental regulatory compliance matters, as well as permitting related to land development issues. Diana handles a wide variety of legal matters for a diverse group of clients, from large Fortune 100 companies, local, regional, and family-owned businesses, and public entities. She's worked on significant matters for the firm, including several litigation and regulatory matters involving the permitting and construction of a multi-billion-dollar energy infrastructure project in Pennsylvania. Diana is a magna cum laude graduate of Drexel University, Thomas Klein School of Law, where she has served as a teaching assistant for civil procedure in the academic skills program, and was also a member of the Drexel Law Review. She returned to Drexel as an adjunct professor, where she currently teaches toxic torts litigation. She's been recognized in the listings for Law 360's Rising Star since 2020, the Best Lawyers Ones to Watch for Environmental Litigation since 2021, and the Pennsylvania Super Lawyers Rising Star for Environmental Law and Litigation since 2014. She was also named to the Legal Intelligencer 2017 Lawyers on the Fast Track listing, and was recently included as a 2022 40 Under 40 honoree by the Aldea magazine. So Diana today is going to be talking about Pennsylvania's Environmental Rights Amendment and how it can affect our industry. So please join me in welcoming Diana.
Thanks. Thank you. Thank you. Thanks for the introduction. It's long-winded, but sorry about that. So that multi-billion-dollar pipeline project that's mentioned in my bio, not by name, a couple people in the room know what that is. That's the Mariner project, which this is the joke I've said at other conferences, is my other child, because I was expecting when we were permitting when Mariner 1 became Mariner 2, and then my child is now 6, and I'm still working on the Mariner project. So that's my other child, now 7 years in the making. So the Environmental Rights Amendment, I just want to do a quick poll. How many people have ever heard of it? So 3 or 4. Okay, and how many people who heard of it, well, I'm going to pick on Lauren, but have ever had that impact any of their projects in the oil and gas industry? Okay, Lauren. I was going to pick on Lauren. Okay, so I want to explain this crazy thing that's in our Constitution that no one knew. And don't feel bad if you didn't raise your hand, because I'm an environmental lawyer, and until about 7 years ago, I didn't know it existed either. So it's an interesting thing that actually exists in the Pennsylvania Constitution, and it has impacted and can potentially impact oil and gas industry, and it has in the last several years. I'm going to talk a little bit about sort of the developments, what local townships are doing, and the cases that have developed in this field. I'm going to show you a video that is also directly relevant from a gentleman you all will recognize. So my next slide.
Here in the Commonwealth of Pennsylvania, we have a constitutional right to clean air and pure water. It says so in Article 1, Section 27 of our state constitution. It's a right that was enshrined in our state constitution back in 1971, at a time when the cost of failing to protect our natural resources was truly devastating for the Commonwealth. Mountain streams that once teemed with trout, well, they had turned into toxic runways decades ago. The people of Pennsylvania learned a tough lesson firsthand, that the health of our children and our economic future actually depended on protecting our environment from reckless profit and unchecked corporate interests. While we've come a long way, certainly, since those days, there is still this painful gap that exists between what our Constitution guarantees and, in reality, what exists in some parts of our Commonwealth.
All right, so this was from the press conference that A.G. Shapiro had on Friday about the Mariner and Revolution projects, which got a lot of press for 24 hours, and probably people forget about it. But the very first sentence out of his mouth after that plea was entered was about the Environmental Rights Amendment. And while that case had absolutely zero to do with the Environmental Rights Amendment, it is a soundbite that people are using against the industry in various forms. And so I wanted to talk about what it is and explain how it has impacted and may continue to impact oil and gas development, particularly in Pennsylvania. So in the Constitution, if you read it, if you're bored and you want to read the Pennsylvania Constitution, in 1971, the Environmental Rights Amendment was added as a specific right. And so here's what the language is, and I'm going to talk a little bit about this and how the squishy language, just like all parts of the Constitution, have been used sort of for pro-issues and anti-issues. So the language is really broad and really sweeping. It says, the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all people. This was added to the state constitution in 1971, and you're going to say 71, that's kind of a weird time period for this. But what's really important about this is that it's in Article 1 of the Constitution. So that's the same level of protection for your constitutional rights as the right to bear arms, the right to trial by jury, the right from unreasonable searches and seizures under the criminal, Fourth Amendment rights, right to freedom of the press, freedom of religion. It's literally the same level of protection for the environment. Most people don't know that, and most people don't really even knew it existed until kind of recently, really where it's become, and I'll go through this, really with the Marcellus shale boom is where this has come more to the forefront. All right, so this interesting amendment, it actually was passed by an insane margin. It was unanimous in both the Pennsylvania House and the Senate, and because it's a constitutional amendment, all the voters in Pennsylvania had to vote on it in the election in 1970, and it got ratified in 1971, and it was 80% of the popular vote. So sitting here today, that's pretty amazing. In 1971, people were so in favor of this, it was ratified by 80% of the popular vote. Pennsylvania is not the only state that has this. There's only 3 states, and I'll go through them, that have a constitutional right for the environment. New York just passed it in 2018. It basically was nearly identical to Pennsylvania's, and this was a huge push very directly against the industry. And so anyone who's ever heard of the Delaware Riverkeeper and Maya Van Rossum, she wrote a book called The Green Amendment, and she's been sort of peddling it state to state, and New York was the first one to adopt it recently. So now New York also protects the environment in the very highest right of their constitution and is going to likely use it for various issues. Montana is the other state, which seems odd, right? Like Montana, you think that's a red state, like non-environment, big sky country, but Montana also in 1972 adopted a very similar amendment to protect the environment for the benefit of all. And so until very recently, it was just Montana and Pennsylvania, and then New York kind of copied Pennsylvania's law. Sorry, is that it? We don't have to care about these 3 states? No. So many other states have thought about doing this, and many other states are on their way to doing it. So in 2022, so this year, 9 states have either continued actions to enact a constitutional amendment or are in the stages of going through the sort of hoops that you have to go through to amend their constitution. So some of these aren't surprising, right? Hawaii, okay, that makes sense. Maine also probably makes sense. You'd see that one. Kentucky, that one surprised me. Kentucky, New Jersey, I don't know. I drive up 95 in New Jersey from sort of the Philly area to New York, and it's the industrial sort of mecca of how the United States developed over time. There's a lot of industry right along that 95 corridor in Elizabeth and Newark and all the ports. New Mexico, Iowa, Washington, okay, Pacific Northwest. Yeah, you can kind of understand crunchy folks up there. West Virginia, I know that's important for this room. And so, I didn't want to go into detail of all these because it would take me all day, but there are various statutes and proposals at each of these states, and they have been for several years, trying to get them ratified both by the House and Senate in each state, and then ratified on a ballot as a referendum each year. New Jersey actually tried it a couple years ago, and it failed, and so they're trying again. So please ask questions as I go along. If you guys have questions, just interrupt me. All right. So what the heck does this mean? I think that's the most important thing. Most things in law don't make any sense until you sort of read them and break them down. What this all comes from is this concept It's an old concept from colonial time, the concept of the commons. So the idea is back in the day when everybody lived in New York City, they would have this common area where they would let their sheep graze and they would let their cows go to pasture. And if everybody used that resource and everybody used it too much, it would deplete and would go by the wayside. So the idea is that somebody up here, some higher authority, has to try to work so that everybody gets their equal share and preserves that common resource. So that's where the underlying thought process comes behind this constitutional amendment, is that we all own something together as humans living in this Commonwealth of Pennsylvania, but everybody wants to use it or exploit it a little bit for themselves, and if you let one person do it too much, that can harm everybody else's use. But what the heck does a constitutional right to clean air, pure water, and the preservation of natural, scenic, historic, and aesthetic values of the environment? What's clean and what's pure? We all know that's a relative term there. And who determines what values to sort of ascribe to those things? How can you have a right to something individually? Like, I can wrap my head around the right to bear arms. I have my pistol, I understand that. But how can you have a right to the air? What does that mean? And how does that thing as an individual right to you as a person when we're supposed to all own it together? And what does this all mean for the existing sort of body of regulations and statutes that exist from the feds, the states, on the Clean Streams Law, the Air Pollution Control Act, the Oil and Gas Act, which we'll talk about? What does this mean if there's all these regulations, but there's a constitutional right to something and it also overlaps? And what about this highly detailed system that many of us live in with our projects, where you have to cross all the I's, cross all the T's, dot all the I's, and meet all these really onerous conditions that the EPA puts on you, DEP, the US Army Corps, all the alphabet soup of agencies we all work with? What does that mean? If I'm meeting all their rules, isn't that enough? And what I'll talk about very specifically today, what about the counties and the localities? Do they get a say, and what is that say? And that's really where, in the oil and gas industry, this issue has come up in the last 10 years. It's really about local townships, local counties, and the anti-groups and nonprofits saying, not in my backyard, I don't want something here, or actually sometimes the opposite, I do want something here, come industry, come to my township, and opposite people fighting it. All right, so how's this really worked? Since the 1970s, this thing's in the Constitution, and honestly, it was like a sleeper cell. No one really paid attention to it. And generally, DEP took the position that the state's environmental statutes and regulations are enough. They were all enacted with the goal of preserving the environment and also allowing for the exploitation of resources and the use of industry in sort of a proper manner. So how the Commonwealth has said they fulfill this obligation of being the super kind of power over the common good, their trustee duties, was we enact regulations, we enact statutes, and implementing those, we meet the Constitution. That's sort of how it's worked, and how DEP, even today would say that's kind of how it works. And some of that is actually written right into the regulations and into the statutes. It literally specifically says the intent of this statute or regulation is to implement the Environmental Rights Amendment. So the Solid Waste Management Act actually says that, first line, it says that. Other ones don't, but the gist is DEP, or the state would argue, that's the point of the entire body of environmental regulation. All right, so in the 1970s, you kind of never heard about this. A lot of us haven't heard about it still. So then what happens? The Marcellus boom. It came to the forefront again. It says, okay, since the 70s, no one's really paid attention to this, and I'll explain some of the cases in the early days, but really the boom was what made people, oh wow, there's something in the Constitution that I could look to that, depending on what my goals are, I can use that to sort of control a project or try to stop a project. The first big case, the huge case that started it all again, so nothing from the 1970s, I'll talk about the early 70s, to 2013, so 40 years or so, was Robinson Township versus the Commonwealth of Pennsylvania. And what that was they challenged the enactment of Act 13, the amendments to the Oil and Gas Act, to allow for Marcellus shale development, and said it was unconstitutional. And we'll go through that case a little bit in detail, because that was sort of the foundational wake-up call that, oh, there's this thing in the Constitution and people can use it for certain agendas. Then there was a case in 2017 the Pennsylvania Environmental Defense Fund versus Commonwealth, and that was about oil and gas leasing on DCNR property. What happens to the money that some of our clients and our folks that we deal with pay? Where does it go, and can it be used for anything, or does it have to be used for environmental issues? And then one that's really interesting, that's not exactly oil and gas industry, but just kind of interesting, was this UGI Utilities versus the City of Reading, and there's a Lancaster County case too. And what that was local township ordinances trying to restrict exactly where you could put a gas meter just for service to a home or a business, and how that had to deal with like a historic district. And in that case, very clearly the Supreme Court said, or the Commonwealth Court said, and the Supreme Court affirmed, that a local government can't just sort of do what it wants. It can't just point to the Constitution and say, I get to make up the rules locally if there's a state or federal statute that says, no, you're allowed to do this, or no, you're not allowed to do this. And that was really what it said. It says the PUC regulates this. You, local township, can't just point to the Constitution and say, I get to make up the rules now. All right. So almost every case that has come out in the Environmental Rights Amendment in the last 10 years has been in the oil and gas arena. So every single case that I'll talk about is all challenges to a local ordinance or a local regulation or DEP action, and how that overlaps with the Constitution. So just to kind of real quickly talk about some of them, and a lot of them are out in this part of the state. Frederick versus Allegheny Township, it was a bunch of citizens who challenged a zoning ordinance that allowed for oil and gas development anywhere in the township. Come. This was kind of the opposite. It was the opposite of not in my backyard. It was the township saying, we want this development anywhere you're allowed to do it. And a group of residents said, no, it should be in certain areas. The City of Lancaster case was the other mention of that outside, where you can put a gas meter, very similar to the case I just mentioned in City of Reading. Murraysville Watch Committee versus the Municipality of Murraysville Zoning Hearing Board, a citizen group challenging a permit for an unconventional oil and gas well. And that was allowed as a conditional use in the Township Zoning Code, and a local group of citizens said, we don't like this and we want to challenge it. Grant Township versus DEP and PGE, which is actually a case I'm handling, where a township adopted an ordinance, and then it became a home rule charter, and they're trying to change it all, that completely bans the disposal of fracking waste in any form. It can be solid or liquid. And here, it was a direct effort to try to prevent an underground injection well that PG had a permit for from both the EPA and DEP. That case is still going on. And then really recently, there's a case for Olympus Energy in Westier Township, where it was a denial of a conditional land use permit for a well pad. All of these cases, somewhat in some manner, started at a local level and were all about what the local townships could do to regulate the industry. There's some more. So other cases where township tried to pass some sort of restriction to curtail oil and gas development. There's two cases for Range Resources. One was the township ordinance trying to basically prohibit and regulate oil and gas drilling by requiring very specific local permits that were pretty much impossible to get. Another case, also against Range brought, where the township ordinance said, if you have any environmental violation ever, no matter if it's sort of the traffic tickets that DP gives out or the county conservation districts, your silt sock falls over, you cannot do business in our township. Not surprisingly, that was declared improper. Huntley versus Huntley, it was a township zoning code that only allowed oil and gas development and drilling by conditional use in one very specific place that made it pretty much impossible for you to do it. That was also overturned. Penco Environmental Solutions, same thing, township zoning code, tried to prohibit an underground injection well, very similar to the Grant Township issue, by saying, nowhere in our township are you allowed. So these are a lot of cases, but what you can see from these cases is local counties and municipalities, or sort of groups of citizens or nonprofits that have a lot of funding, are using the Environmental Rights Amendment as this vague, generalized concept in the Constitution to say, I have a reason to tell you no, and here's my constitutional right to tell you no. And they're really trying to, a lot of these townships in these cases are trying to creatively thread the needle on what they're allowed to tell you to do and what they can't tell you to do. That's something within the ambit of DEP or FERC or the Army Corps or the EPA. All right, so what are the limits? What can these people do and what can't they do? So generally, what this all boils down to, and the cases are all still going all over the place, and there's cases brought on these issues all the time. Local townships or counties can regulate the where. Where can you put your facility? Through zoning, subdivision, traditional ordinances for anybody, for a shopping center or a housing project. So they can do that, but when they start getting into the how am I gonna actually develop my project and how is it gonna operate? Those cases, and I'll talk about them, say they can't do that. A local township, local county can't tell you how. They can tell you where within reason. If they say nowhere, that's also not okay. But they can't tell you how. And basically the Supreme Court in this Huntley case I mentioned said a local law can't allow what is forbidden by state law. And conversely, they can't say no, they can't prohibit what is allowed by state or federal law. So they can't go beyond sort of their little box that they're in as a municipality. Any questions so far? Okay. So I mentioned that nothing really happened in the 70s and that it all came back in 2013. I happen to have graduated law school right in 2011 when this all started, so I've been pretty much doing this from the beginning. So in 1971, the ERA amendment is ratified by the voters of Pennsylvania. The very first 2 lawsuits happened within 2 years and had nothing to do with the oil and gas industry, had to do with the Gettysburg battlefield. And then 2012, under the Corbett administration, Act 13 is enacted, and generally, if you guys all remember, it said it was to propagate oil and gas and make it available sort of and easier to sort of do throughout the Commonwealth. And the case that came out of that, Robinson Township, said, you went too far. Allowing it everywhere and allowing localities not to have any say is too far, you can't do that, and I'll talk about that. And then this PDF decision. All right, so the first couple cases that came out of this had nothing to do with oil and gas. Oh, the other thing I would mention on that timeline that I just went back to, as you can tell from AG Shapiro, wannabe Governor Shapiro, it's not going away. This isn't something that's just going to go by the wayside and people forget about. I think for political reasons, both at the state, local level, and obviously the governorship, it's going to be a soundbite, and it's going to drive certain people's decision making a certain way. Okay. All right, so the first case had nothing to do with oil and gas, and really the only case that came out before was about the Gettysburg battlefield. And what was interesting about this, and what is kind of key to how then it morphs into 2013 in the oil and gas industry, is that this was a case where a private person on private land was trying to build something. They wanted to build an observation tower adjacent to the Gettysburg battlefield, and the Pennsylvania Attorney General tried to stop it. He said, no, we don't want that there. We don't like that. And I'm going to point to the Environmental Rights Amendment and say a private person on private property is not allowed to do what they want because it's going to impact these amorphous historic and aesthetic values. And so the Commonwealth Court said that the Environmental Rights Amendment is self-executing, meaning you don't need laws, you don't need regulations, it just exists in the void, sort of like the right to bear arms or the right to freedom of the press. And so that they affirmed the trial court that said that construction of the tower would not injure the natural, scenic, historic, or aesthetic values of the battlefield. The Supreme Court affirmed this, and they said, no, you can't stop, just pointing to the Environmental Rights Amendment doesn't mean you get to stop a private person on private land trying to do what they want, because it doesn't impact all these things in this amorphous provision in the Constitution. So then the next case was the same year, and it was, again, the opposite. It was actually a private party saying, state, you're doing something, state of Pennsylvania, that's wrong, that I don't like, and I'm going to use the Environmental Rights Amendment to try to have my lawsuit. And in here, it was a challenge to a PennDOT proposal to widen a street that would take 6.6 acres of a dedicated public common, like a public space. And so a private person said, the state, you can't do that because under the Environmental Rights Amendment, you're supposed to preserve that for the benefit of everyone in the state, and now you're destroying it. And so the Commonwealth Court said, all right, how do we figure these out? What's the rules of the game here? And it can't mean that you can't have any development in the Commonwealth. That can't be what people said in 1971 and 80% of the population voted for. That can't be what it means. So what they said is there's going to be a 3-part test. we're going to say, is there compliance with all the regs? Is there compliance with statutes, regs, anything relevant to the sort of Commonwealth public natural resources? Has there been a reasonable effort to make it as less of an impact as it can? And then does the environmental harm so clearly outweigh the benefit of the project that to proceed further would be an abuse of discretion? So that's what existed since the 70s. And then they basically said, they affirmed it, and they said, yeah, it's okay, you can do that. But they also said that it is self-executing, meaning it exists in a vacuum. This environmental rights amendment exists regardless of what state laws and regulations say. It just exists sort of as this superpower above it. And the Supreme Court recognized that the General Assembly, our elected representatives, have to sort of balance the protections of the environment that's in the Constitution with allowing for reasonable development and industry to occur in the state. And then they found that legislation protecting public areas for highway purposes, in this case with PennDOT, has things about if there's no feasible alternatives. And in a lot of the environmental statutes that some of us work in, it says no practicable alternatives or no alternatives. So if there's something in there that smells like you have to do a balancing test and sort of figure it out, that's okay. That probably meets the Environmental Rights Amendment. So nothing happened for 40 years. When I mean that, this three-part test was generally adopted, and pretty much every case that ever brought it up, and there was only a handful, said, okay, look at that three-part test, and really for environmental permitting, for the projects we all work on, what the Pennsylvania Environmental Hearing Board said is there's really no difference between what the constitutional amendment says as what we have to sort of judge and call balls and strikes at the Environmental Hearing Board for projects. Did the DP do their job? Did the applicant do their job? Is this an appropriate sort of project with the environmental regulations? And so at least in most of the projects that came up, if it ever came up, they said, we sort of already do this. We don't really need to pay attention to the Constitution. All right, so then Robinson Township happens. I kind of told you about Robinson Township already. And they said, no, that three-part balancing test where we got to say, okay, is this good for sort of society and is this good for industrial development is a good thing? They said, no, screw that test, forget it. And they said, actually, what we're going to do is we're going to split this constitutional amendment into two parts. There's an individual right that we sitting here all individually have. The people have the right to clean air, pure water, preservation of natural, scenic, and historic values. And then there's the trustee part that says the Commonwealth, whatever that means, is going to hold the common good of the environment as property of everyone sort of forever. And at least in Robinson Township, what they said is the state, here it was the General Assembly who enacted the oil and gas amendments, said the Commonwealth has a duty to refrain from permitting or encouraging the degradation, diminution, or depletion of the public natural resources, whether such degradation, diminution, or depletion would occur through direct state action or indirectly, e.g. because of the state's failure to restrain the action of a private party. And so what they key said to sort of, I mentioned all these things come up with municipalities, is they said the local role, the protection of the environmental and aesthetic interests is a key part of local government's role. Which I think many of us thought, well, what do we have the DP for then if the local government's supposed to have this sort of key role? This language in this opinion, which was a 200-page opinion, specifically was the thing cited by a lot of these townships to say, no, I don't want your project, or no, this is my obligation, independently from the state agencies. So what did it do? That case, if we all remember, struck down a bunch of the provisions in the Oil and Gas Act. It struck down Section 3303, which was intended to preempt any locality from trying to regulate anything in the oil and gas industry. And Section 3304 required all townships to basically allow for oil and gas development in their locality, in their zoning code, in their subdivision code. And then Section 3215B imposed modest oil and gas well location restrictions in reference to sort of sensitive water resources, but the DP could waive those if they wanted, and they said that was inappropriate because if the DP can just waive it, then it's not really a protection. And so they struck down these three provisions of the Oil and Gas Act, and everything else stood, everything else was fine. because directly, they said these three provisions directly violated the Commonwealth's duties and obligations under the Environmental Rights Amendment. And because specifically that they restricted local townships and local counties, all the municipal governments in Pennsylvania, from having an active role in deciding whether or not a project could be there. And it basically stripped their ability under the Environmental Rights Amendment to act as a trustee. The locality is also a trustee and supposed to make sure that everything is kosher environmentally, historically, aesthetically. All right, so the next big case came out from an environmental nonprofit that was pretty well funded. It's PEDF. This case has bounced around, and it's up to a 7th decision that just came out on Friday. So this case has been all over the place. And this is the one that I mentioned about oil and gas royalties on state-owned property. And so in 1955, there was a statute, the Oil and Gas Lease Fund Act, that required all the revenue generated from oil and gas leases on state lands to be deposited in a specific dedicated fund that was only to be used for conservation, recreation, and DCNR type activities. Then in 2008 and 2014, there was 3 legislative enactments, 3 other statutes that got passed that decided to take $335 million that would have been into this lease fund for only sort of state park purposes and redirect it to the general fund to balance the budget. And not surprisingly, people didn't like that too much. And so an environmental nonprofit group actually challenged it for that exact reason, saying that under the Environmental Rights Amendment, if you're going to lease out the property to be developed for oil and gas, the money should come back to that environmental purpose of DCNR and the state parks. All right, so what happened? So same thing, they rejected that 3-part test I mentioned. They split the right into 2 parts, the individual right and the trustee obligations. And here they really focused on what is the state supposed to do? What are they supposed to do as the trustee, the superpower deciding and calling balls and strikes? And so what they said was the phrase "for the benefit of all the people" clearly indicates that the assets of the trust, which here is money that oil and gas developers were paying to the state, is to be used for conservation and maintenance purposes, not to balance the budget. The oil and gas royalties were part of the corpus of the trust. It's just a legal word, body of the trust. Like, if you have a trust for a kid, it's the same concept. And the Commonwealth must manage them pursuant to its duties as a trustee. And then they said the legislative enactments that directed the payments to go to balance the budget and thus permitted the Commonwealth to use royalties for non-trust purposes, non-environmental purposes, were facially unconstitutional. That was totally not allowed. And so this case has gone up 3 more times to decide, really, is that true? Can the Commonwealth give any money back to themselves to sort of pay for their employees with money that is generated by oil and gas leasing? And just this past Friday, on Friday, August 5th, there was another Supreme Court case, it's PEDF 6, there are 6 cases, that said, actually, you could pay some of it to pay the general fund. And what it said was, just like a trustee, if you have a trustee set up for a family member, for someone who needs help, they have to pay to administer things, pay court fees, pay everything. So the state should be able to pay itself a little bit to manage sort of the trust, which is the state parks. So they said up to 1/3 of the money generated from oil and gas leases on DCNR property could be paid to balance the budget, the general fund that goes to DCNR. So it doesn't all have to go to conservation purposes. It could actually be used for part of it. But they said 2/3 for conservation purposes, 1/3 to pay your salary. Why? I mean, the case goes into it. It's a really long opinion, but who knows why? They just thought that sounds good. Let's make that up at this point. All right.
So is that one done?
Who knows? I mean, right now it should be done. And that's PEDF 6. 6 Supreme Court decisions on that case, but who knows? That environmental group is really, really well funded, and they may challenge it again. Okay, so before the most recent one I mentioned, right after they said, no, Commonwealth, you can't use money to balance the budget you get from oil and gas leasing. 2 months later, there was a case in front of the Environmental Hearing Board where really, okay, now we got to reject this 3-part test that balanced everything and said, protect the environment, but make sure reasonable development happens. and Robinson Township happened. So now, like, many of us were thinking and scratching our heads, well, like, what's the first case that's gonna come out where a permit, something you're getting from DEP or an approval, and someone challenges it under the Environmental Rights Amendment? And so the Environmental Hearing Board said, okay, I guess we gotta pay attention to this now. Remember I told you before, they said, we don't need to pay attention to that Constitution, we kind of do our job properly. Now they said, okay, now we have to pay attention. And what they did was say there's a two-part test. So basically, they said for the first time, when I look at a permitting decision of the department, rejection or approval, as the Environmental Hearing Board, I have to determine not only is it going to meet all the statutes and regulations that the permittee and the applicant meant, but I also have to think about whether it violates the Constitution. So as a permit applicant, you have to think about that too. And so what they said was, looking at the individual right, that each person has a right to the clean air, pure earth, all that stuff. First, they have to say, did the department consider the environmental effects in the permitting action? Well, of course they did. They're the State Department of Environmental Protection. And what they looked at was really how robust was the permitting process. In this particular case, which was for a coal permit, they required detailed information, like really highly detailed information about the environmental effects of the project. There were 7 years of permit applications, meetings between DEP and Council Energy, several revisions to the permit, a bunch of public meetings. So yeah, they did everything right. They really considered the environment. Okay, that's not enough. So then they said whether the action, meaning the permitting decision, is likely to cause or did in fact cause unreasonable, that's a very squishy word, degradation or deterioration of the waters of the Commonwealth. And what they said was longwall mining has social utility, and it's the type of development leading to an increase in the general welfare, convenience, and prosperity of the people of Pennsylvania. If it lacked that characteristic, meaning the economic benefit and sort of the social benefit and jobs, it would more than likely be judged unreasonable. So the Environmental Hearing Board said, okay, yeah, I look at all the environmental issues. I understand that this thing could cause, on its face, environmental harm. I mean, obviously mining causes some issues. But what's the social benefit to the Commonwealth of Pennsylvania? And if there's some social benefit there, or economic benefit, it probably still passes the test. And so what they did was said no violation of the Environmental Rights Amendment, this permit's properly issued, it met all the regulatory hurdles, and it's okay to go forward. All right, so there's a bunch of cases that came after that I'll just go really quickly. The board had 2 other decisions sort of the next year, and what they said again, you can't just look at the regulations and the permitting in a vacuum. You have to also think about whether this thing that you're doing meets the Constitution, and if there's a no violation of any regulatory standard, and you're meeting all the checks and checks the box, and de facto there's not going to be a violation of the Environmental Rights Amendment. So if your permit application meets all the requirements in the statutes and regs, probably not going to be a violation of the Constitution. And conversely, if it doesn't meet all of the requirements, it probably is a violation of the Constitution. And so that's basically what these 2 cases said. Permitting, all the regulations, if you satisfy them, you probably satisfy the Constitution, and if you don't, you don't. So the one about the big case that came out that really was talking about townships and all those other cases I read at the beginning was this Frederick versus Allegheny Township Zoning Hearing Board. And so the real open question was, what does the Environmental Rights Amendment impose on localities? It talks about the Commonwealth being the trustee. Who's the Commonwealth? When I think about that in the abstract, it's the state agencies, and it's the state elected representatives. Well, here, what happens with municipalities? Can they regulate things or can't they regulate things? And so really the outcome of this case was municipalities lack the authority to regulate in areas that are already covered by DEP or EPA, depending. The court said that the zoning ordinance that said that oil and gas development was only allowed as a permitted use by right in all zoning districts, including residential and agricultural districts, subject to certain standards related to safety and security. This was back where I started at as sort of the punchline. They can regulate the where you put it, they can't regulate how you do it. And this is the first time anyone said that. So what the case said is basically zoning necessarily requires municipalities to think about or account for natural, scenic, historic, and aesthetic values of the environment. But to all the other stuff about how you do it, when can you operate it, all that kind of stuff, do I need a hyper regulation on my waste? Municipalities lack the power to replicate the environmental oversight that the General Assembly has conferred only upon DEP and to other parallel state agencies. So they said, where's okay, not how is okay. Does that make sense? Anyone have a question about that? Okay. So there's been a lot of cases. I already kind of went up front. A lot of them, I'll just touch on that I didn't mention before. Protect PT has been up and down and up and down. That was another citizen group saying allowing something by a special exception in a zoning district is not okay. Murraysville Watch was similar. Grant Township I mentioned, which was an outright ban to the disposal of fracking waste. That was declared unconstitutional for a different reason. It was a different reason because they said only corporations can't do this. They said they made a distinction between companies, and if I was a private billionaire that wanted to do it, I wasn't restricted. So that was unconstitutional. It's basically equal protection. All right, so open questions on this. After all these cases came out, and they're still coming out like every day, like the Deer Township one's actively in trial right now. Who's the Commonwealth? Is it the state? Is it the state agencies? Is it the governor? Is it all these localities that are sort of a creature of allowing to exist? Because localities and municipalities only exist because the state allows them to. They don't independently exist. There was basically state government, and we allowed ourselves back in colonial times to split up more locally because the General Assembly allows you to do that under the Municipal Planning Code. What are the public natural resources? So does that mean that a private pond on my property, I have a 60-acre property, it has a 10-acre pond on it, is that a public resource? Is that my private resource? If someone doesn't like what I'm doing there, can they sue me saying you're violating my constitutional rights? What about oil and gas below the earth? Is that the commons or is that on the individual? And there's obviously a whole other body of law about that I won't get into. But what about the air? Okay, if we all drive cars and emit things into the air and you have a facility that emits something into the air, is that a violation of my constitutional rights if I don't like that facility next door? What are the Commonwealth's obligations under the Environmental Rights Amendment? Are they supposed to do more? Are they supposed to really restrict development and really make it very onerous if we're supposed to have pure water and clean air? Nothing's really pure or clean, so what does that mean? How do we determine when the state takes an action, whether it's in or out? What's the balls or the strikes? And what does it mean for DEP permitting decisions that you meet all the criteria, but now there's this other step you got to jump into, and it says you can meet all the criteria, but maybe you don't actually meet the Constitution requirements. And is compliance with DEP law and regulations enough? A lot of these cases have challenged saying DEP doesn't go far enough. I want more. I want more restrictions on the activity. Are any of Pennsylvania's statutes and regulations in the environmental arena constitutional? If they allow you to do things that make the air less pure or the water less pure, is that unconstitutional? Because there's some person that says you're violating my fundamental right, just like my rights for, to bear arms or to have free speech. And really the key issue, I think, that where all these cases recently are developing and are going to continue to develop is how far can a local township or county who doesn't want you to be there go to say, I have this environmental constitutional obligation, me as the township person sitting here, your facility is going to, no matter which way we cut it, change the environment in my township. Am I allowed to say that's a violation of the constitutional rights of my entire, elected representatives, on behalf of the citizens who live here? And that's really, I think, the key issue that you see all those cases I put up there, all township zoning hearing boards and local townships challenging, or a citizen group in a neighborhood. All of them are fighting that fight using the constitutional amendment. And I think really the key issue in terms of takeaways is if you are doing a project in a township that might not be that friendly, or if you have a neighborhood group or a citizen group that's not too friendly towards your project, you got to think about that early on. And you got to plan for it, both in your permitting and sort of your public relations, government relations, and see what kind of carrots you can give them, because eventually those carrots are going to be either required of you or part of that balancing test. Did you do enough? Are you allowing reasonable development to happen, but also protecting the environment? And it may mean you need to do more than what you would otherwise want to do. And so I think that's planning ahead of time and knowing that if you're in an area where people might not want your project, it's going to result in one of these alphabet soups of lawsuits, and it's not going to go quickly. So I talked a lot. Anybody have any questions about any of this, or curious on how it's going to work or what's happening?
How are the local townships or whatever paying for their legal cases? Is it just the tax dollars of the people in the township?
So what's a real fun? I'll give you my example. So the Grant Township case I mentioned is largely funded by this national environmental nonprofit called CELDEF, the Conservation Environmental Legal Defense Fund. They've been paying all of the township's legal fees because otherwise they couldn't do it. And so there are these organizations like the Sierra Club and NRDC and all these that will fund the fight as they see it. And the Mark Ruffalo's of the world too, if you've seen those movies. In that case, the Grant Township case, before I got involved at the federal level, when they said it was unconstitutional to say a company can't do this but a private person could, they sought legal fees of like $700,000, and they claimed this will bankrupt the township. We're a township of 1,000 people. We don't even have a police force. And the federal court judge didn't care. She said, you knew you were doing something wrong and you kept doing it. And so while I'm not going to award PGE all the money, I'm going to award them something. And too bad if you can't pay it, which was basically what they decided. And she also sanctioned the attorneys directly who brought it. So yeah, I mean, that's the thing. A lot of them can't pay for it. A lot of them get funded, and then taxpayer money goes towards it.
Well, and that group that you said was really well funded, that was
PEDF, yeah.
Keep the money set go to the general fund.
Yeah.
Are they also funding cases that are anti-development for oil and gas?
It's
kind of odd to want the money from oil and gas, but then not want the development to further.
Yeah, it's sort of circular. Yeah, PEDF is definitely sort of an environmental nonprofit anti-group. And I think they found their argument with you're trying to balance the state government's budget with oil and gas royalty leases. But you're right. I mean, it's sort of circular. Why are you? Right. They wanted the money only to be used. If oil and gas is going to happen, they can't really prevent that. I only want the money to be used for conservation purposes. And not that the state parks, I love the state parks, they need money, but they only need so much money. Like, come on. Like, how many rangers do they need in the end? No offense to any park rangers in the room, but yeah, sure.
Two things I was going to say. I had a project in Penn Township, or a number of pet projects.
Yeah.
Penn Township and
Protect PT, yeah.
Active, and we had to go through the zoning hearing board to get special exception approval of, to get 7 well pads.
Yeah.
And I think we got through like 2 or 3 of the hearings, and they did not grant the special exception because we did not prove that we were going to protect the environment enough.
Yeah.
Even though we had all of our DEP permits, we had done everything we needed to do, we had all the requirements. So it was this very vague, like you didn't do enough to prove to us you would protect it.
Right.
And I wasn't as involved going through all the litigation on it. Reed Smith was part of that.
Yep.
And but I think ultimately what it came down to is the operator took them to court, and it was gonna, I think, go up to Supreme Court.
Yeah.
And I think the township then realized, like, holy cow, like we don't have the money maybe to do this, and they ended up kind of negotiating a few things, and then we got the approvals. But that was kind of I think that one didn't go as far because the township seemed to realize, like, oh shit, we don't really.
Yeah. And the issue there, and that's a great example because Protect PT in Penn Township is one, and that's gone bounced up, is then even if the township gives up, to your point, Drew, like, okay, yeah, we're David versus Goliath, which honestly they are. I mean, we all sort of are in the same industry. But what happens is then that doesn't stop a citizen group or a nonprofit from saying, well, then the zoning hearing board got it wrong. They got it right the first time and they gave up. And that's how some of those cases keep bouncing back and forth between the local courts, then the intermediate appellate court and the Supreme Court. And that'll keep happening. Because all of these vague standards, reasonable, clean, that's not defined anywhere. So how do you define those things? I mean, I think that's the biggest challenge. Like you said, like you didn't do enough in that case. Well, what's enough?
Aren't all the politicians attorneys to begin with? Don't they know better than to get terms in the
they're not the good ones, no. That's a great question,
Another thing I was going to ask you about, I have another project I'm working on where the operator went through the Act 2 process with the state and is complying with everything that they need to comply with, but the Attorney General has decided that the DEP has not done enough, the Act 2 program is not adequate, so
Yeah.
the Attorney General is going after the operator. Like, at what point is, I mean, the Attorney General can just do whatever he feels like it. At what point are you like, no, actually, they did what they were supposed to do, so you can't continue to go after these people?
Yeah, I mean, in general, like, that's why you have separation of church, I'm going to say church and state, but I don't mean church and state, but that's why you have a separation between the executive branch, which the AG falls into, and the legislature falls into that too, and then the court system. It's supposed to be separate. It's supposed to be that then checks and balance on what, in your example, the AG does, and what, the 9 members of the Pennsylvania Supreme Court says really the law is. Yeah, at what point is it totally done and not subject to challenge? To be honest, when someone gives up. When someone gives up, or there's a Supreme Court case that says it's over, and even Robinson Township, I didn't get into like the sordid history there, that went up and back like 3 times. And so there was, one Supreme Court decision and then another one, and so when is it over? I don't know. I guess us lawyers are making a lot of money off of this, but it's not. It doesn't. It's strategic. Okay, how much longer do we want to fight as a applicant or someone trying to do business in these locations, or what are we just willing to give them to kind of make them stop?
Because you mean the state Supreme Court when you say Supreme Court.
Yeah, I meant the state Supreme Court. Generally, these issues, technically there could be a petition then to the federal Supreme Court. It would never be granted. I mean, it could be, but I doubt it on something like this. Yeah?
When you were talking about commonwealths, which I find very interesting, like Virginia or Pennsylvania.
Massachusetts, yeah.
In Massachusetts, inherently, especially with water rights, not oil and gas, it's a gray area for private ownership.
Uh-huh.
It's really not, if you take it literally, the state owns all the water rights.
Yep.
It's a fair statement.
Yeah, that's a fair statement. I mean, it is. I mean, you could have a private pond on your property, and it could be technically that's a water that the Commonwealth has. Usually now it's, if your property line goes to the mean high water mark, there's like some rules. But you're right. I mean, technically, someone's not trespassing. Here's a good example. Not trespassing on their property. If they entered a stream from some public place and walked in the middle of the stream up to your house, that's okay because the stream bed is public land.
Yes.
Yeah.
Is there anything in the works for providing some sort of legal time frame for challenges? Hey, you've met
Yeah.
from a federal level, hey, you've gotten FERC, you've gotten Corps of Engineers, you've gotten the local, you've gotten the state, and Sierra Club comes in and goes, no, I don't like it, and I'm going to take you to court over NEPA or whatever piece of paper they want to pull out and say, I'm challenging it based upon this. Okay, well then, you've got your timeline, and if you don't pass that litmus test, here's your permit, you're over, you're done with, you have to go, or, hey, the government is the one that messed up. The government has to refund the oil and gas company all of their expenditures for permitting, delineations, design, because you failed to do your job. It's not the oil and gas problem. We filled out our paperwork, you said it was fine, and you were found not competent in issuing your permit.
Yeah, there's a lot packed into that. So yes, there's timeframes for appeals and challenges of permit issuance or permit denials. Typically, it's 30 days after the permit, whether it's the Environmental Hearing Board or FERC.
MVP is an example.
Yeah, exactly. MVP is going back and forth for 7 years. Yeah. So MVP Mountain Valley Pipeline. Yeah, it's true. And so that one has a little overlap of the federal issue and state issue. Wouldn't it be nice if they refunded all the development, the pre-development costs? I don't disagree with that. I think that'll probably never happen. Where it has happened is under, at least in Pennsylvania, the Clean Streams Law. If you can prove the DEP did something wrong, either in denying your permit or granting it if you're on the other side, you can get your fees, attorney's fees, back from the state government. And the state government, DEP, hates that. And they try to make you, every time you settle with them on any little ticky-tacky violation, make you sign away your rights to attorney's fees because they got hit with a huge one. And that's another case for the Mariner Pipeline that is at the Supreme Court right now that we're handling, which is the whole thing. So I don't disagree with you. I mean, I think the issue is all that well and good. There's certain things like specific about appeal rights, 30 days after permit issuance. That all is set in regulations and statutes. But what if I have a constitutional right? That exists in a vacuum, and that exists. I can sue anybody anytime under the Constitution, and there's not really a statute of limitations or a time period that applies to that. So far people have kind of gone down the lanes that I've explained, but I think, okay, I just bring a just constitutional claim with nothing else attached to it, no other statute references, and just say, you're violating my right to pure air because I live next to a landfill. I'd use a non-oil and gas example, and it smells. The air is not pure. And like objectively, that's true. You can measure methane, right? What if someone doesn't like, anything? You could come up with anything that's either gonna say it is not pure air, pure water, or harming aesthetic. Who decides what's pretty or not? I mean, that one's even more amorphous. Like, I don't like what it looks like. Cell phone towers with the sort of fake trees, that's an aesthetic value. They could say, well, under the Environmental Rights Amendment, I, township person, must make this look like a terrible Christmas tree.
Aren't
Yeah.
they already doing that when they're like, when communities are suing farmers for spreading manure, and the farmer's been running the land for, 50 years before the community was developed?
Yeah.
Well, whose right supersedes who?
Yeah, exactly. And most of those cases end up in like nuisance law, but the Environmental Rights Amendment could be used too. No one's done it yet, but they could. Yeah.
Have you seen if any of this is kind of influencing DEP's decision making, like when they release new guidance? Like, are they kind of worried now, seeing what's coming of this?
So they have a whole division of DEP lawyers now that all they do is this now, is the Environmental Rights Amendment, and track it. That's like literally like in central office in Harrisburg at the Rachel Carson building, there's 4 attorneys that do nothing but Environmental Rights Amendment. And that old way of thinking that DEP had, well, if I follow the rules and the regulations and I cross all the T's and dot all the I's in my permitting, I'm good. I don't think that exists anymore. They're still kind of like for run-of-the-mill stuff doing that, but if it's a hot button project that they know is going to get challenged by someone, they're looking at it more in this amorphous bubble. And so where they're not going to put that in guidance, they do have an Environmental Rights Amendment policy on their website that talks about this, and that all permitting decisions will take that into account. But I would say practically, it's going to come up in the really sexy ones, not in the run-of-the-mill like Act 2 permit. It's when someone they think it's going to challenge, they're going to start focusing on it more. I don't know if that sort of answered the question backwards way.
And do you know, like, specifically, like, the Chapter 1 and 5 changes? If, like, I didn't read all the comments and stuff, but I would imagine that environmental groups are pulling that card.
Yep, I would say literally every environmental hearing board appeal is a third-party appeal, which is most of the time, it's the third-party challenge to a duly issued permit, right? The Sierra Clubs, the Clean Air Council, most of the stuff I do, they always cite it. Whether it actually becomes part of the case and they really get into it, everyone throws it in there. This permit that's issued violates the Environmental Rights Amendment. And so it is, the contours of this is honestly, the contours are all over the place. As you can tell from the 30 decisions that come out, it kind of depends on the facts. And that's not a good place if you're trying to project time, money, and value on a project.
How does DEP have the authority to issue a permit?
Yeah, exactly.
If you pull out this constitutional amendment, then the DEP has no regulatory permitting authority at all.
Right. I mean, the cases have basically said, okay, the legislative enactment, the General Assembly saying the Solid Waste Management Act, the Clean Streams Law, the Air Pollution Control Act, these things in their regulatory ambit are affecting, or meaning they're effectuating, they're making them come to be under the Environmental Rights Amendment, the trustee obligations. We're managing this common area with the sheep, and we're going to allow people to use it, but not use it too much. Generally, that's what the courts have said, and that's what DEP would say too. But in a certain circumstance, and unfortunately, the bullseye's always recently and probably for the next foreseeable future going to be on the oil and gas industry, it's going to be what does that really mean on the edges.
Have there been any efforts to rewrite the amendment or repeal the amendment?
Yeah, I don't know of any current ones. I do know of different, certain people, every time they come up with a new bill that has some type of heightened environmental protection, whatever, political aisle comes on, cite this. So not to repeal it or get rid of it, but more to explain why their version of some kind of heightened restriction or outright ban on something is justified. And the Attorney General loves it. I mean, it's the very first thing out of his mouth on Friday with the Mariner and Revolution pipelines. My jaw dropped at that because I was very highly involved in that. And I said, wow, first thing he says, constitutional amendment, which has nothing to do with what's happening right now. Great. Any other questions? This was great. Thanks, guys.
Anything else?
No?
You had your hand up a second ago, Matthew.
Yeah, go ahead, Matt. Yeah.
Same thing. I'm aware from the metals industry where third parties sue the Pennsylvania DEP for not enforcing strongly enough against a big local metals company here.
Yeah.
And then it forever holds that company, their law department, they have to for years spend money and defend themselves.
Yeah.
Even though it's the DEP that's being sued over that action.
Yeah.
So it makes me wonder so it's the same question. If the permit can't exist or it can be challenged, can somebody take it to the U.S. Supreme Court and say, hey, this Pennsylvania environmental right is not greater than some other right to due process?
Yeah, and so it can. So where you would get to from a state court to the Supreme Court of the United States has to implicate a federal question, a federal issue. So where I see it there is, if it would happen, it'd be something like the Environmental Rights Amendment in Pennsylvania is unconstitutional because it unreasonably restricts private property rights under the federal Constitution. Something like that in the right scenario. That could happen. Would the Supreme Court ever actually do that? Probably not, because they get to pick and choose which cases they want. But it could in the right circumstance. And, and could then the Supreme Court of Pennsylvania declare the Pennsylvania Environmental Rights Amendment unconstitutional? I think very, very highly unlikely, but I guess it could. I mean, hypothetically it could. So it passed by 80% of the popular vote in 1971. I mean, that's like during right before the OPEC crisis. It's just crazy to me.
that was the Nixon administration.
Right.
The Clean Water Act, Clean Air Act.
It all came out of there.
It was all at the same time.
Right. Okay, great. Thanks, you guys. Thanks so much. It's great. Thank you.